focused on whether any person violated the law in connection with efforts to interfere in the lawful transfer of power following the 2020 election. Is that correct?
Yes.
At the conclusion of that investigation related to the interference in the lawful transfer of power following the 2020 election, when your office indicted Mr. Trump for his criminal scheme to overturn the 2020 election, did you believe that you had sufficient evidence to obtain and sustain a conviction against Mr. Donald Trump?
Yes.
For these charges stemming from Mr. Trump's criminal scheme to overturn the 2020 election, did you believe that you had sufficient evidence to prove these charges beyond a reasonable doubt?
Yes.
And we know that it's more than just a reasonable doubt. Did you believe that there were multiple substantial federal interests in proceeding with prosecuting Mr. Trump after he attempted to criminally overturn the 2020 election?
I did.
Now, the second investigation that you were appointed to lead focused on the possession of highly classified documents at Mr. Trump's Mar-a-Lago social club following his presidency. When your office indicted Mr. Trump for willfully keeping highly classified docs after he lost the 2020 election, did you believe that you had sufficient evidence to obtain and sustain a conviction against Mr. Donald Trump?
Yes.
And for these charges stemming from when Mr. Trump left the office in 2021 with these highly classified documents, did you believe that you had sufficient evidence to prove the charges beyond a reasonable doubt?
Yes.
And did you believe that there were multiple substantial federal interests in proceeding with prosecuting Mr. Trump for his unlawful possession of these highly classified documents?
I did.
How many years of experience do you have as a prosecutor, Mr. Smith?
In total, I've been a prosecutor a little short of 30 years.
Can you give us a high-level overview of the different offices you might have worked in as a prosecutor?
Sure. I started my career as an assistant district attorney at the Manhattan District Attorney's Office in New York City. I prosecuted local crimes there for 5 years. Afterwards, I became a federal prosecutor in the Eastern District of New York, which is in Brooklyn and Long Island. And I was there for about 9 years. I prosecuted larger, more complex cases when I was there. I was eventually the chief of criminal litigation there. I left that office to go overseas and work at the International Criminal Court for a little short of 2 years. I coordinated investigations of the Office of the Prosecutor there. I then returned to the Department of Justice, where I was the chief of the Public Integrity section of the Department of Justice, and I did that for somewhere between 4.5 and 5 years. I left Washington, D.C. and moved to Nashville, Tennessee, where I was the first assistant U.S. attorney and then later the acting U.S. attorney in the Middle District of Tennessee, which is in Nashville. I left government for the only time in my career. I was worked for a private company for a brief period of time, a period of months, and then I was offered a position by the State Department to serve as a war crimes prosecutor at a European Union war crimes tribunal in The Hague, the Netherlands, and I was there for a little over 4 years before I became special counsel.
I'm sorry to interrupt. Can you just speak up a little bit?
Oh, I'm sorry.
Yeah, the people in the back have trouble hearing you.
Sorry about that.
Okay.
And can you describe the types of cases out of all these years of experience? Just give us a broad overview of the seriousness of the cases that you've brought in your career.
I've worked on all sorts of cases. Early in my career, I was a member of the offices in Manhattan, the domestic violence unit, and so I did a number of cases of people who are abusing domestic violence victims. Those are some of the most memorable cases in my career. I worked on gang cases, RICO gang cases, in the Eastern District of New York. I worked on the Admiral Louima case, which was a assault of a Haitian immigrant by police officers. I did an international murder for hire case, other sorts of violent crime cases. I was one of the night of 9/11. I was part of the command center, and in the weeks afterwards, I was involved in responding to what happened on 9/11. After the Eastern District of New York, when I was overseas, I worked on war crimes cases that were in all sorts of different jurisdictions and all sorts of challenging investigative situations. And political corruption cases, obviously, when I was in public integrity and also in Nashville.
So taking all these cases you described, I heard cases about, gangs in New York. It sounds like there were war crimes cases, there were domestic violence cases just described. Taking all that experience, when you finished your investigation in the special counsel's office, you believed that you had sufficient evidence in this case to prove Donald Trump committed those crimes after the 2020 election?
I did.
And you believe that you had enough evidence to get a conviction with Donald Trump taking or willfully taking the classified documents after he left office in 2020 and returned to Florida in 2021?
That's correct.
So we've heard a word a lot from this administration, from the majority Republicans, and that word is transparency. And yet, Mr. Smith, we're in a closed-door deposition today, meaning that members of the public and even congressional members and staff who are not part of the Judiciary Committee are not permitted to attend this proceeding. Did you offer to testify publicly before this committee?
Yes.
How did you offer? I guess, how did you make the offer to testify publicly to this committee?
I think it was through my counsel.
Did you send a letter to the committee? Did your counsel send a letter to the committee offering to publicly testify?
I think that's right.
We'll enter that letter into the record just for your background. And this will be Exhibit 7. It'll be an October 23rd, 2025 letter signed by Mr. Lanny Brewer and Mr. Peter Koski. It's addressed to Chairman Jordan and Chairman Grassley regarding Mr. Smith's public offer to testify publicly. Are you familiar with this letter, Mr. Smith?
Yes.
Can you tell us why you felt it was important to make a request for a public hearing?
I'm proud of the work that we did at the special counsel's office. I'm particularly proud of the people I worked with, the career public servants I worked with, who've been vilified by President Trump and people who work for him, and I think someone needs to speak up for them.
Did you want to testify publicly because you had something to hide about your investigation?
No.
Did you want to testify publicly to rebut some of these accusations from the president that you just mentioned about your investigation?
Yes, that's what I meant. Accusations not just against me, but against career prosecutors, career FBI agents who have served our country and who've been vilified wrongly. I think it's really important to correct the record on that.
Were you granted the request to testify publicly before this committee? The answer's probably obvious as we sit in this room, but were you granted that request?
No.
Were you given any reasons or provided any reasons why you were not allowed to testify publicly and directly to the American people?
I don't recall that.
Are you aware that even President Trump thought that you should testify publicly before our committee?
I heard that.
Yeah, just to make it clear for the record, Mr. Trump said, and this is a quote, "I'd rather see him," as in Jack Smith, "testify publicly because there's no way he can answer the questions." So let's turn to a few of those questions. Do you recall the October 14th, 2025 letter to you from Chairman Jordan requesting a transcribed interview?
I know he sent a letter asking for me to be interviewed, yes.
We'll enter that into the record and make it Exhibit 8.
Thank you.
And I'll give you a second just to look through it as we pass it out. So in this October letter to you requesting a transcribed interview, the chairman characterized your investigation as, quote, "politically motivated prosecutions of Donald J. Trump," end quote, and said you conducted a, quote, "unnecessary and abusive raid of the residence," end quote, of Donald Trump, and that claimed that you, quote, "manipulated key evidence in the investigation," end quote, among other claims. Do you recall these accusations to you in the letter from Chairman Jordan?
Yes.
The Republicans of our committee have made these letters to you public. You can read it on the committee's website, including these accusations that your office was weaponized. But this proceeding is behind closed doors, and Majority Counsel just warned you earlier about keeping the contents of this deposition confidential. Do you remember that warning that you received at the beginning of this deposition?
Yes.
So we will get into this in more detail later, but just to quickly touch on this, do you agree with the majority's characterization that your office was weaponized?
No.
Was your special counsel's office weaponized in any way?
No.
Did you conduct a politically motivated prosecution of Donald J. Trump?
I did not.
Would you like to have explained directly to the American people why these characterizations are not true?
Yes, and again, particularly as to the career prosecutors and agents who have been vilified.
Are you concerned that given that this deposition is not open to the public and the public cannot hear your answers or observe your demeanor or hear the way that you're responding to questions from the majority, that some of your responses may be selectively published or released in a way that mischaracterizes your answers?
I would hope that wouldn't happen.
But are you aware that's a risk of your testimony here today?
I'm sure that's possible.
Based upon your knowledge, is it generally the practice for the special counsel who investigated presidential conduct to be given the chance to testify at a public hearing to be able to explain their findings to the American public?
Yes.
So let's just take a few of those. Are you aware of special counsel Robert Mueller testifying publicly before the House Judiciary Committee?
Yes.
For the record, that occurred in July of 2019. Are you aware of special counsel John Durham testifying publicly before the House Judiciary Committee?
Yes.
For the record, that occurred in June of 2023. Are you aware of special counsel Robert Hur, who came up earlier in the majority's hour, testifying before the House Judiciary Committee?
Yes.
For the record, that occurred in March of 2024. Also want to touch a little bit on, speaking of just transparency and a fulsome investigation into this committee's request for documents related to your investigation. We're going to enter into the record another letter from Chairman Jordan. This one's addressed to Attorney General Bondi. This letter seeks records related to the Arctic Frost files, and it's dated October 29th of 2025. This will be Exhibit 9. And you might not be familiar with this document, so I'll give you a second to review it. It's not very long, though.
Okay, I've reviewed it.
So after reviewing it, are you now aware that Chairman Jordan has sought the production of files related to your investigation from the Department of Justice?
Yes.
And just to read that request, it's request number 2. It says, in quotes, all DOJ documents and communications referring or relating to Jack Smith's special counsel investigation for the period of November 18th, 2022 to January 20th of 2025. I just want to get a better understanding of this broad request of all DOJ documents and communications referring to your investigation. I guess what types or categories of documents are associated or would be associated with your investigative files?
There would be numerous documents. I mean, it was a prosecutor's office, so the sort of documents you would associate with a prosecutor's office.
Just to make it clear for the record, can you just give a few examples of what those records or memos might look like or what they might be about?
Prosecution memos, email correspondence with my staff, analysis of the case, things of that nature.
Would these documents include internal decision memos or other records of major decisions made by you and your team during the investigation?
Yes.
Do these files include communications with the Attorney General or the Deputy Attorney General during the course of your investigation?
I don't think I had any files that would fall into that category. I'm not sure if there'd be, my deputy also communicated with the Deputy Attorney General's office, so there may be, but I don't think that's to me.
Do these files include communications just with other DOJ offices? I think earlier you mentioned possible communications with the Solicitor General. Would those files include possible communications with that person?
Yes.
Can I just follow up on that for 1 second?
Sure.
You had no communications with the Deputy Attorney General?
No, I took the question to mean in terms of like email or things of that nature. We met, I met with the Attorney General, the Deputy Attorney General, at times at their request. So those things did happen. I'm just saying I don't recall me having any sort of email communications with either of them.
But in terms of the special counsel offices, just following up Mr. Golden's question, the office as a whole, if there were email communications between members of your team and the Attorney General or the Deputy Attorney General, would that probably be a part of your special counsel case files?
Yes.
And as far as you're aware, the current Department of Justice has full access to your documents and memos and files from your investigation, is that correct?
They should.
In fact, you reviewed those files in preparation for your appearance today, right?
Yes, we were given access to a computer that had files on it. I can't say that it's all the files, but we were given access to that, and I reviewed that in preparation of today.
Did you follow DOJ protocol in your decision-making, including consulting with relevant offices like the Public Integrity Section, the Office of Legal Counsel, and any other entities as required and encouraged by DOJ policy?
Yes.
Were there examples where these consultations were memorialized in writing, either before or after you met with these offices?
Yes.
So given the majority's claim that the investigation was biased, do you think the case files would help eliminate some of the majority's questions about the actions you took while special counsel?
I have no objection to people looking at the case file.
To your knowledge, has DOJ released all the special counsel's files, either to Congress or to the public?
I don't know what they've released to Congress.
Do you believe it's in the public's best interest to view the full case file rather than just selective samples as they've come out so far?
The reason I'm pausing is I'm not sure it's proper for me to weigh in on that. I don't know if there are, for example, confidential information regarding witnesses that shouldn't be made public. And so I think that's a matter for others besides me who have the case files in their possession now to review and decide.
So let's just narrow it a little bit. Do you think it would be beneficial for the committee to review the case files so we can understand why certain investigative steps were taken?
I'm going to leave that to others to decide. I'm here and I'm happy to answer any questions you or anybody else might have.
If the case files were released, would they include any political considerations by you or your team as you investigated and charged these cases?
We did not consider politics. I did not consider politics, anyone's politics in charging these cases.
And that would be borne out, presumably, by the case files?
I'm not aware of anything in the case files that would contradict that.
Because it never happened.
It never happened.
I also just want to note the authorization that you got from DOJ, and I think this is marked as Exhibit 2. No, sorry, Exhibit 3 by the majority. It was quite broad, right?
Which one is this now?
This is Exhibit 3, a letter from the Department of Justice to your counsel.
Apologize, we've got a lot of letters here, so.
Take your time.
Just don't have a lot of evidence
Here you go.
that's been disclosed.
Okay, I have the letter now,
Okay,
yes.
so I'm looking at page 3 on the bottom, but this letter essentially walks through a series of topics that you are authorized by the DOJ to discuss.
Correct.
Okay. So on the bottom of page 3, I'm reading here from the letter. The extraordinary events underlying this matter constitute exceptional circumstances warranting an extraordinary accommodation to Congress in this particular case. Given these extraordinary circumstances, to the greatest extent allowable by law, the Department authorizes Mr. Smith to provide unrestricted testimony to the committee, irrespective of potential privilege, including the names of line attorneys and agents in the department as it pertains to the matter identified in this letter, and as limited in paragraph 1 through 5. And the paragraph 1 through 5 essentially goes through the investigations that you undertook and I guess a couple of tangential matters related to the Office of Professional Responsibility and the Arctic Frost investigation. Is that correct?
That's what that says, yes.
Okay, so given that DOJ gave you unrestricted or authorization to provide unrestricted testimony, would it make sense that DOJ then should also give this committee unrestricted access to the case files that's currently in its possession?
I'll leave it to others to decide that. I will say that the paragraph you read is different than it's been with past special counsel. Past special counsel usually testify about the contours of their report. They've changed the process here, and I'm still here willing to answer questions.
Okay, thank you.
I believe we're on Exhibit 10 now. We're going to move on to Exhibit 10, which will be your Special Counsel Report, Volume 1, dated January 7th of 2025. I know this is a document. I know this is a document you're very familiar with, but we'll pass it around. So as the date of your report says, on January 7th of 2025, and as your time as special counsel was coming to an end, you provided a final report to the Attorney General where you explained the prosecution and declination decisions that you made as special counsel as required by 28 CFR 600.8. Is that correct, sir?
That's correct.
What was your goal in preparing this report?
I wanted to, at first, make sure I fulfilled the obligation under the special counsel regulations to do a report consistent with the regulations.
And was this final report an accurate account of your investigation and its findings?
It was.
Based upon your understanding, is it generally the practice for a special counsel's report to be made public to the American people?
I believe so. I know at times they've been, portions have been redacted in the past, but my general understanding is yes.
So to the best of your knowledge, do you recall Special Counsel Mueller's report being made public?
It was public, yes.
To the best of your recollection, do you recall Special Counsel Herr's report being made public?
Yes.
To the best of your knowledge, do you recall Special Counsel Weiss's report being made public?
I don't recall. It may be, I don't know.
Was your report made public in full?
This report as to the elections case, I believe it was made public.
Did you have a separate volume or a volume 2 of your report?
That's correct.
Was that made public?
No.
Touching on volume 2, in your letter to the Attorney General, you also recommended that volume 2 of this report, which discusses the classified documents case, not be publicly released while the cases of Mr. Walt Nauta and Mr. Carlos de Oliveira remain pending. Do you recall saying that in your letter to the Attorney General?
That's what's in the letter, yes.
Can you explain, please explain why you included that recommendation?
When, as special counsel, when you draft a report like this, it's not for me to decide whether it gets made public or not. It's for the Attorney General, and it's for him to also to decide what portions, if any, get redacted in that. And so what I stated was my, in essence, recommendation that it should not be public because these cases are pending and there are facts in here that it might not be fair to have that be public while they have charges pending against them.
Understood. So other than the fact that the cases of Mr. Nauta and Mr. Oliveira were still pending, as you just discussed, did you have any other reasons to believe or to recommend that volume 2 of the report should not be publicly released?
Well, again, that wasn't my choice. My choice was to write a report for the Attorney General to make a decision about whether it would be public. I have no objection to it being public, and I didn't then, as long as it complies with the law in terms of 6C and other issues like that.
Yeah, but just going back to that recommendation, in making the recommendation in the letter that it not be made public, understanding that it's the AG's decision to release the report, did you have any other reasons for making that recommendation other than the ongoing cases of Mr. Nauta and Mr. Oliveira?
I'm sorry, I misunderstood your question. No reason other than that.
Is there any other reason right now, since Mr. Nauta and Mr. Oliveira's cases are no longer pending, is there any reason now that you can think of, other than Judge Cannon's order, where volume 2 of the report should not be released?
Judge Cannon's order is the reason.
Excuse me, can I jump in? Do you know who was responsible? Did you dismiss the Nauta and Oliveira cases?
No.
Do you know who dismissed them?
I don't recall, but I imagine it's a matter of public record.
If I told you that it was after Donald Trump was inaugurated, would you agree with that?
I don't recall, but if that may well be true.
For the purpose of this remaining conversation, since that's a publicly identifiable fact, I will represent to you that it was done by the Trump administration. You charged that case, correct?
Correct.
you went through your extensive experience as a prosecutor. Do you believe that Mr. Nauda and Mr. Oliveira were guilty of the crimes that they were charged with?
Yes, we believed that we had proof beyond a reasonable doubt for all the charges and that we would have gotten convictions at trial, yes.
And are you aware of any reason within the rules, protocols, and regulations of the Department of Justice that that case should have been dismissed?
In my view, no, it shouldn't have been.
Real quickly, before I turn over to Mr. Jayapal, are you able to speak about Volume 2 today?
I'm not.
Can you explain what you can and cannot speak about with respect to Volume 2?
Well, there is an order of Judge Cannon, an injunction regarding Volume 2. I want to make very clear that I do not want to do anything to violate that injunction or that order. And so, given that I have not seen, looked at Volume 2 since I submitted it to the Attorney General almost a year ago, I do not have a exact recollection of what is in there and not. And so, unless something is in a public filing, or, and people can point me to a public filing, or in, I think, the category that was mentioned in the letter that we got this morning of publicly, I can't remember the terminology, but properly publicly released information. I do not want to, I want to be clear, I do not want to violate that order, and I don't want to do anything that could even be remotely construed as violating that order.
Wait, so, I'm sorry, but DOJ did not let you review Volume 2 of your report?
It may well have been there, but I chose not to review it because I didn't want any implication whatsoever that I was somehow violating the order by looking at it, not being a member of the department now.
So before we get to Ms. Jayapal, I just want to clear up two things. One, so you've been an assistant DA, you've been a federal prosecutor, you were an international criminal court prosecutor, you were the chief of the public integrity section at DOJ, and you were first assistant U.S. attorney in Nashville and the acting U.S. attorney. Do you have any idea how many cases you've actually handled and prosecuted?
That I've handled or supervised others handling, I'm sure it's in the thousands.
In the thousands, okay. Have you ever been prosecuted for selective prosecution, vindictive prosecution, or partisan discrimination?
Never.
Have you ever fired a prosecutor because they refused to engage in a prosecution on grounds that there was not sufficient evidence?
No.
Okay. And in all of the cases that you have supervised and prosecuted yourself directly relating to domestic violence, relating to conspiracy, relating to murder, relating to war crimes, have you encountered the problem of witness intimidation?
Very much so.
Will you speak a bit about the problem of witness intimidation and what that does to the rule of law and justice?
Witness intimidation is probably the most corrosive thing that can happen to the rule of law. And that is why, as a young prosecutor, you are taught to move your cases expeditiously, because you know that if there is someone trying to obstruct your case, the longer they have to do that, the more they can subvert justice. And I've worked on a number of cases. I've worked on murder cases where witnesses were murdered. I've worked on cases overseas involving very serious witness intimidation and obstruction of justice. And as I mentioned earlier, this case as well. And so that was foremost in my mind as we were conducting these investigations, but it's something I've encountered in different contexts throughout my career, even back to those domestic violence cases that I started in earlier in my career. Attempts to threaten or influence those witnesses are a way to subvert justice.
So what kinds of actions and precautions can you take as a prosecutor to prevent it and to try to protect witnesses against intimidation and violence?
So depending on the situation, there would be different sorts of steps that you could take. Obviously, if it's an imminent threat, like someone's coming to kill the witness today, you try to move them and protect them for a period of time. But if it's a more pervasive threat where a defendant or people on his behalf are issuing statements and issuing threats, trying to get people not to cooperate with your case, or trying to make an example of people who have cooperated with your case, the best thing you can do is limit their ability to make those threats and shorten the time they have to make those threats.
Thank you. Let me go to Ms. Jaipal.
Can I just, one thing on volume 2 before we go? It's obviously a case related to classified documents. Without getting into the detail, how was it how was it written? Was there an unclassified portion and a classified portion, or is the classified material interwoven in the volume?
I don't think I should even talk about that. I don't want to have any implication that I gave some sort of insight about how that report is constructed. And so I don't really think I could speak about that given her order.
Can I ask you this question? Is it possible to release parts of that report while also protecting classified material?
I very much want to answer your question, but I don't want to say anything that will imply what is in the report, and so unfortunately, I don't think I can answer.
Okay, again, I'm going to go to Ms. Jaipal. We'll come back to you. Yeah.
Thank you. Mr. Smith, I want to get to questions of transparency again, but I want to pull out to a bigger question. Do you think that it's important for our democracy to hold free and fair elections without interference or obstruction?
Yes.
And theoretically, what happens if there is election interference and the people who are responsible for that are not held accountable?
It becomes the new norm, and that becomes how we conduct elections.
And so the toll on our democracy, if you had to describe that, what would that be?
Catastrophic.
You stated in your testimony in the first hour that you've tried to be as transparent as possible with the American people about your investigation. The chairman of the committee has repeatedly put out that you were subpoenaed for your testimony today, and in fact you are here under a subpoena, but you have requested to appear voluntarily in a public hearing. Is that correct?
Yes.
And why were you willing to appear voluntarily in a public hearing?
We conducted our investigation in a way that I'm proud of. I'm particularly proud of the people I conducted the investigation with, and I wanted to speak for them.
And is it generally the practice of special counsels to appear in a public hearing? I know you have a couple of questions on this, but I want to reiterate this.
That is my general understanding, yes.
And can you tell us again why I understand you want to stick up for the prosecutors, the people that were part of the investigation. Can you tell us why it's important for the American people to hear directly from you about your investigation, what you discovered, the process that you went through?
Well, as I said in the beginning of, I think, in my opening remarks, there have been mischaracterizations about my work. We did our work in the best traditions of the department, and I know I keep coming back to this, but the attacks, the mischaracterizations that most offend me are not just prosecutors, but career FBI agents, support staff in the department. These are people who devoted their lives to public servants, to being public servants. They have not, they're not self-promoters. They're not people who like to go in front of the cameras and defend themselves. And I feel that they have been vilified in a way that I think is awful.
What's the effect of that on our democracy?
Well, I think it drives people away from public service.
Yeah. Is it a form of witness intimidation?
I think it's even deeper than that. I think, you know, when we get to attacking the people who are the good guys,
Yeah.
I just don't know where that goes. It's counter to how I was raised.
And let me ask you, even after this deposition today, are you still willing to appear at a public hearing before this committee and speak directly to the American people about your investigation?
Yes.
Can I jump in really quickly just on the witness intimidation issue? As I understand it, you were asked a lot of questions about filings that your office made as it relates to trying to protect witnesses, specifically the gag orders. Do you have any regrets about the steps that you took as it relates to seeking gag orders against this defendant in an effort to protect witnesses?
Our applications for orders limiting Donald Trump's ability to intimidate witnesses, intimidate court staff, intimidate my staff, I have no regrets about that.
Dovetailing on that, have you only been further convicted in the decisions that you decided to make as it relates to that in watching some of the president's actions even in present day?
I think the record of our case speaks for itself on these issues.
Could I just follow up on the gag orders relative to the defendants? In every case, a judge decided that that was warranted, correct?
In the cases in the District of Columbia, a judge
Right.
did decide that, and the Court of Appeals agreed. They narrowed the order, as I said earlier. In Florida, we applied for an order because of statements Donald Trump had made that I viewed endangered FBI agents. That hadn't been decided when the case was dismissed.
Thank you.
And just to kind of finish up on this point, you yourself, I'm not sure if this was discussed by the majority, but have you yourself been intimidated as a result of the actions that you took in this case?
I'm not going to be intimidated.
Have you been threatened?
Yes.
Have you learned of other persons, whether they worked under you as attorneys or other support staff? Are you aware of any threats that have been made against any of them?
Yes.
And, okay, I'll stop there.
Mr. Magoo?
Thank you, Mr. Smith. I really have two questions. First question, which our counsel ably covered, just so we're clear, you wanted to testify publicly today, correct?
Yes, I was willing to.
And Chairman Jordan declined that opportunity, correct?
Yes.
Any thoughts as to why Chairman Jordan is scared to have you testify in public?
I'm not going to characterize the chairman's decision. I offered, he decided that we would do it in this setting, and that is what it is.
Well, I think Americans who review this transcript, once it's concluded, will understand why. If you have any questions.
Mark, let's come back to you.
Thank you, sir. I'm going to switch gears a little bit to your appointment as special counsel. Do you recall when you were appointed as special counsel?
Yes, it was November, I believe, November of 2022.
Does November 18th of 2022 sound right?
That sounds about right.
Do you recall the day that Donald Trump announced his candidacy for the 2024 election?
I believe it was shortly before that.
So who offered you the position of special counsel?
The Attorney General.
And what was your understanding of why the Attorney General felt it was necessary to appoint a special counsel in this circumstance?
I believe the Attorney General made a public statement about why, and that public statement is my understanding.
We can maybe enter that public statement in a little later. But what did you understand the scope of your investigation to be specifically when you were appointed?
The scope was defined by the appointment order, which encompassed the two investigations that I've referred to today.
And can you just make the record clear again, just briefly describe those two investigations and then appointment order?
Sure, and I don't have the order in front of me, so just generally.
Actually, so we'll make that an
Yeah.
exhibit. We'll make it an exhibit. Let's make the appointment order an exhibit. And this will be exhibit 11, I believe. Make it easier just to refresh your
Sure,
recollection.
thank you.
So after you've taken a minute to review it, and please take your time, the question will be, what did you understand the scope of your investigation to be?
Okay, so consistent with this order, the scope was two investigations, both of them ongoing at the time. The first was an ongoing investigation into whether any person or entity violated the law in connection with efforts to interfere with the lawful transfer of power following the 2020 presidential election or the certification of the Electoral College vote held on or about January 6, 2021, as well as any matters that arose or might directly arise from this investigation.
Do you know why, or have you heard why the Attorney General chose you to be the special counsel?
Why he chose me?
Yes.
No,
Okay. At the time of your appointment, I understand you were living in the Netherlands. Is that correct?
that's correct.
Did you lobby for this position?
No,
Did you petition the Attorney General to be the special counsel?
I did not.
Did you reach out to any former colleagues of the Department of Justice expressing your interest in being the special counsel?
I had been in contact with a former colleague by the name of Marshall Miller. He had returned to the department sometime that summer, and I had spoken to him and expressed to him an interest in, if there was the right position, returning to the department.
Ultimately, why did you accept the special counsel position?
Because I thought I was the right person for the job. I knew that this would be a challenging job. I knew it would be a job where whoever held the job, or whatever decision they made, somebody would want to attack them for that decision. And I felt that given my nearly 30 years as a prosecutor, made me uniquely qualified to do the work.
Did you have any reservations about accepting the special counsel position?
No?
There were a lot of attacks on you shortly after you were named and throughout the time as special counsel. You said earlier, I think you used the term intimidated. I guess, how did you move forward consistently with those attacks while special counsel?
I think attacks and praise are noise, and as a prosecutor, I've learned to tune those things out. I'm more concerned, again, about the attacks on my staff. But for myself, I understand that that's can be part of the work at times.
Did you accept the role, as some have suggested, because you had animus towards President Trump?
No.
Did you accept the role, as some have suggested, because you hoped to influence the 2024 presidential election in favor of the Democratic nominee?
No.
Did you accept the role because you thought it would help the Democratic nominee by prosecuting Donald Trump before the election took place in 2024?
No.
Let's consider the same facts related to the attack on the Capitol on January 6th or the mishandling of classified documents. So that's the facts that we're going to consider here. Take the same facts but insert a president who was a Democrat. Would you have still accepted the role of special counsel?
100%.
Considering the same facts, so the same fact pattern of the attack on the Capitol on January 6th, the same facts of unlawfully taking classified documents after leaving the White House, would you still have accepted the role of special counsel to investigate former President Barack Obama?
Yes.
Again, considering the same facts, would you have accepted the role of special counsel to investigate former President Joe Biden?
Yes.
Looking back, and you've talked about the investigation steps that you've taken here in the deposition today. I think I've heard you talk about, process of an investigation and how that's important. Would your investigative process have differed if the President of the United States would have been a Democrat?
No.
Someone have a follow-up on that?
Yeah. I served on the January 6th Select Committee, and we spent a lot of time looking through the criminal statutes that may have been implicated in the attack on the peaceful transfer of power, the attempt to overthrow the election, and then the violent assault on the Capitol. And we, in our conclusions, cited a number of statutes which ended up, I think, being part of your investigation, including conspiracy to obstruct a federal proceeding, conspiracy to defraud the United States, false statements, and so on. But you added something which I think was very interesting, which was a conspiracy to violate voting rights, which is something that we hadn't done. And I wonder if you would take a moment to expound on why you thought you had sufficient evidence to prove beyond a reasonable doubt that there was a conspiracy to violate the voting rights of the people.
Sure. The right to vote in a presidential election is one of the most sacred rights that Americans have. And in this particular case, we had strong evidence that the defendants in this case sought to interfere with, obstruct, injure that right. We had evidence, and just a couple examples, where President Trump was asking local officials to find 11,000 votes. When you find 11,000 votes, you're diluting other people's votes. We had evidence that they were targeting certain states and particularly certain parts of certain states, generally urban parts of states, to have those votes thrown out with no factual basis whatsoever. I believe we cited this in our final report, but there's even statements of the co-conspirators in this case, at least one it's coming to mind now, specifically saying we want to get rid of these votes. We want to subtract them. And diluting the vote count in that way, there's strong precedent for that being a violation of the statute that we charged.
There were 60 federal or state court decisions rejecting claims of electoral fraud, electoral corruption that had been brought by President Trump or his teammates. To what extent did that figure into your analysis of that problem?
Well, the lawsuits, we made clear in our indictment that there are proper ways to dispute an election, and asking for an audit, which President Trump did, and I believe in only 2 of the states that were in question, that's a way you can do that. Filing lawsuits, completely legal and proper way to do that. But in this case, those lawsuits were part of our proof that put President Trump and his co-conspirators on notice. The suits, the results, and the things that court said in finding those suits without merit were one component of evidence that put him on notice that these allegations were false. Also, there were instances where there were pretextual lawsuits. There was one lawsuit, for example, that was filed in New Mexico minutes before the deadline, so they could say there was a dispute in New Mexico so they could proceed forward with the fake electors ballot. There was another lawsuit in Georgia where one of the co-conspirators explicitly said in an email, we're on notice that the things in this lawsuit aren't accurate, so we shouldn't have the president sign a certification of this lawsuit. And then they played with the language a little and had him sign a certification nonetheless. And so these lawsuits, well, filing a lawsuit absolutely clearly is something you can do. They were probative evidence of the criminal intent in this case for those limited reasons I just suggested.
Can I go back to volume 2 just for a second? You said that the department gave you access to volume 2 and you chose not to use it?
That's correct.
Did,
I believe so. I did not, given the injunction, want to look at that. And so I believe it was there, but I was looking at other things and I didn't look at that.
Did they give you access to any classified information that was a part of your files?
No.
Did you or your attorneys have any discussions with the department about that?
I don't recall.
Do you still have your security clearance?
No.
When and how was that taken away?
I think in the normal course of things, when you leave government service, you sign papers basically saying you don't have your security clearance anymore. It's vague, but that's my recollection of what happened at my conclusion of my service.
Okay. Do you know if your attorneys requested for you to have temporary security clearance so you could review your own files?
I don't believe we did.
And because you didn't look at the volume 2 that they provided to you, you don't know whether or not classified material was provided to you in that volume?
Again, I don't want to speak about anything that could infer the content of volume 2.
When you provided volume 2 to the Attorney General, did you provide proposed redactions?
I believe we did, but I believe we did.
And the redactions
But
were...
I just want to be, I'm sorry to interrupt you, sir. With the understanding that it was ultimately the Attorney General's decision whether to make it public, whether to do redactions, things of that nature.
And what were the nature of your proposed redactions?
I don't recall as I sit here now.
Was it related to the classified information?
I don't recall. It could have been 6E, it could have been things of that nature.
Did you make proposed redactions because of your concern at all about the ongoing case against Noda and Olivera?
I don't recall that, but I can't be conclusive. I really don't have a good memory of the subject.
Thank you.
I'm curious, shifting gears just a little bit. When you first sat down, the majority was asking you questions that seemingly were tied into the general duties of a prosecutor, and your resume has been laid out. It is interesting, or at least it was interesting to me to hear the majority characterize who should be prosecuted under the current circumstances. I'm not sure if you've followed along, but are you aware that under this DOJ, they have indicted Tish James as well as they ultimately indicted James Comey? Are you aware of that?
I am.
And are you also aware of the fact that this DOJ has consistently dismissed members of the DOJ for refusing to bring forth indictments that they don't believe have merit?
Yes.
The majority was asking you about why it is that you characterize your belief that there was guilt as it relates to the indictment that you sought. As a trained prosecutor, typically, are you supposed to go after people that you don't believe are actually guilty?
I'm trying to, there's a couple of negatives in that question.
I know.
Yeah.
They were trying
You're
to.
not supposed to go after people who you believe are not guilty.
Okay, thank you. In your experience of 3 decades, have you ever needed to seek the same indictment 3 times while being rejected?
Never.
Okay, I think that's all I have for that.
Have you ever prosecuted someone that you did not believe was guilty beyond a reasonable doubt?
Never.
As we hit, I know we're getting close to the end of our time. I want to hit on a few questions, and I apologize if they come off as very obvious to you with your experience and the way that you conducted yourself with the Department of Justice. Did Attorney General Garland or other DOJ officials direct investigative steps within your office of the special counsel?
No.
Did Attorney General Garland or other DOJ officials direct litigation decisions within your office?
No.
Did you experience Attorney General Garland or other DOJ officials interfering with your ability to conduct this investigation?
No.
Did President Biden ever give you any instructions about what you should or should not do related to these investigations?
No.
Did you ever speak to President Biden about these investigations?
No.
I think Mr. Moskowitz has a question.
You know the definition of retribution is? Webster's definition to noun.
Off the top of my head, I do not.
If I proffered that it was exacting a punishment against someone, would that sound better?
Yes, yes,
Your lawyers lost their security clearance, is that correct?
yes,
People who worked under you were fired, is that correct?
that's correct.
You're here today on a deposition that Sherman has brought you into, but I wouldn't give you a public hearing, is that correct?
Yes,
Did you see the comments by the President's Chief of Staff talking about retribution?
I did.
So, everyone was fired. You're here on a deposition. Your lawyers lost their security clearance. It seems like it meets not only the definition in Webster, it seems like this is exactly what Trump's Chief of Staff was talking about. No?
I have no doubt that the president wants to seek retribution against me. I have no doubt that that's the intent.
I don't want to put you off. In
Yeah.
fact, the exact quote was, he doesn't wake up thinking about it, but when there's an opportunity, he goes for it. I mean, this seems like a opportunity. Do you think the White House gave instructions to Chairman Jordan to set this deposition?
So I am eyes wide open that this president will seek retribution against me if he can. I know that. I don't, frankly, connect that with this hearing. I don't have any connection. I came here, I was asked to
No,
come
you
here.
think there were 0 conversations between the White House and Chairman Jordan?
I don't know, but I'm here in good faith, and I was asked to come testify. I
What's the
offered,
likelihood that there were less than 0 conversations between the White House and Chairman Jordan?
I'm not going to speculate on that. I will say, I agree that this department wants to seek retribution against anybody who worked on cases against President Trump. I just don't have any evidence
Why do you think
that,
the Chairman wouldn't give you a public hearing?
that's not for me to say.
I want to go back to your testifying that in every case you've ever brought, you've believed that there is proof beyond a reasonable doubt to demonstrate that the defendant is guilty. I'm not sure it would be even ethical to bring a case if you didn't have that belief. But is there anything inconsistent about having that belief that you can sustain the prosecutor's burden of showing beyond a reasonable doubt all of the elements of the crime are satisfied, and also wanting to see that constitutional due process is observed in the trial? Is there any conflict between those two?
I don't see one.
In other words, as a prosecutor, you go in with the belief that you can make your case, but you also want to make that case within the rule of law and within due process. And you've never experienced that as a problem, right? You've never wanted to trample the rules of due process in order to convict someone.
That's correct.
Okay. Mark, spoke to you. Over.
I just wanted to piggyback on something that Ms. Crockett brought up earlier, but are you familiar with Justice Manual 927-220?
You're going to have to give me more than the number.
All right. So that provision basically states the condition with which a prosecutor can commence or recommend federal prosecution. And I can quote from that section for you. It says, prosecutor may commence or recommend federal prosecution only if he or she believes that the person will more likely than not be found guilty beyond a reasonable doubt by an unbiased trier of fact, and that the conviction will be upheld on appeal. So does that sound familiar to you?
Yes.
Okay. Did you follow this provision when you indicted President Trump in the election interference case?
Yes.
And did you follow that provision when you indicted President Trump and his co-conspirators? Oh, sorry, no, just President Trump in the classified documents case?
Yes.
And his co-conspirators? Did you
In
follow
that case, yes.
Okay. And the majority in their hour questioned you about why you included conduct that has not been found, that has not been brought forth before a trier of fact, right? That has not been proven in a court of law. But aren't you just essentially restating the standard that was that's stated in Justice Manual 927-220?
Yes. With our report, I wanted to explain my prosecutorial decisions, why we made them, the basis for them, and that's why we wrote the report the way we did.
Thank you.
In my last few minutes of our hour, please bear with me as I go through these next questions. There's a lot of inferences and accusations being made about your bias as a special counsel's office, and I want to make sure that we rebut these in the first hour. I think it's important to. So, did the Attorney General or any other DOJ official ever press you to be more aggressive in your investigation of President Donald J. Trump?
No.
Did the Attorney General or any other DOJ official ever suggest that you were expected to bring charges against President Trump?
No.
Did anyone from the White House, including President Biden, ever tell you they expected you to bring charges against Donald Trump?
No.
When you eventually did bring charges against Donald Trump, how did you make that decision? Walk us through it at a high level, if you don't mind.
Sure. It was based on the facts and based on the law. I ultimately made that decision, but I consulted with my team of prosecutors on that case, who were outstanding public servants, people with great experience in complex investigations. I took their advice and counsel in making that decision, and I tried to consider all factors, including both the strength of the case that we believed we had, possible defenses, all things of that nature.
So, which based on what you just said, it sounds like you made this prosecution decision based on the evidence in the law. Is that correct?
That's correct.
What would you have done if you felt any improper pressure from a DOJ official or the White House?
I think people who know me and have known my reputation would know that that would not end well. If someone tried to pressure me to move a case in one direction or the other or wasn't supported by the law, I wouldn't stand for it. And I would also say the people who worked in my office wouldn't stand for that either.
Yep, we're at our hour, so we'll end there. Thank you.